Okay, today we're going to talk about Title IX, anti-sex discrimination in education. And the vocab word is Title IX, part of federal education legislation concerning sex equality in schools that receive federal money. Now, a quick note to note that through this lesson, we are talking about federal legislation. So we will be talking in the binary. Title IX, like other federal legislations, is going through a process of change from the original wording of sex to a process of figuring out how gender identity fits into the existing legislation. But for this lesson, we'll be using the terms of Title IX. Note, this is a very powerful anti-discrimination law, and it has been backed up consistently by the court system and consistently by the federal government. It is one of the most powerful anti-discrimination laws in the history of the United States. Our previous lessons were talking about anti-discrimination and harassment in the workplace. This specific lesson is specifically on education and Title IX, and a future lessons, well, this kind of is close to the end of workplace and education discrimination and harassment unit. So let me start with the wording of Title IX. Straightforward, short, to the point. Quote, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program receiving federal financial assistance. So one may ask, how does the federal government tell schools what to do? Well, this is a long-standing practice of the federal government. If the federal government offers money to a state or to organizations, the federal government can make rules to receive that money. So the more money schools receive from the federal government, the more they feel encouraged to follow the rules of the federal government. And so the power of the federal government under this is they can deny money to schools that don't follow Title IX. And if the schools are getting money, they are required to follow Title IX under the force of law. Now, as a side note, just those simple words, I mean, you can think about it very deeply, but it's not a matter of, is it the top 10 most influential anti-discrimination laws in the history? It's a matter of, is it the top 5? Is it the top 3? Where is it in the top? It is one of the most powerful society, country altering pieces of law ever produced in this country. It started the absolute removal of discrimination based on sex in education, an unbelievably society altering process. And every single number backs up that statement. So at its core was interpretation number 1, basic sex equality in basically everything: courses, sports, opportunities, scholarships, programs. It applied to K through 12 public education because they almost always receive federal funds, and colleges that receive federal funds or federal financial aid even. If the students receive federal financial aid, I do believe, check me on that, it makes them bound under Title IX. So what does this really mean? I mean, you can almost literally just put it in your head right now. Basically, every sex must have access to exactly the same programs and opportunities. It's almost that universal. It's almost that everybody, regardless of sex, can participate in anything the school has. Nothing can be denied by male or female. One sex cannot have access to anything that the other sex doesn't have access to. There can't be a scholarship only for males or only for females. And if there is one only for females, there has to be a corresponding one that would be only for males. There has to be some sort of equity in sports. There can't be clubs for only one sex unless there is a club for equal and opposite, okay? No one can be denied a course. Courses must be open. Programs must be open. Services, facilities, every facility must be open unless there's an equal and opposite. Extracurricular programs. Basically, within 99 or 98%, That's just how you think of it. There's always some sort of little exceptions, but those are very rare. So basically, if you're walking around and you see something that looks discriminatory, chances are it is. The exceptions are very, very rare. And you might see things that are discriminatory, like every single anti-discrimination, anti-harassment, anti-sexual harassment law. Sometimes the organizations, whether they don't know, whether they ignore it, whether it's on purpose, whether it's by accident, they violate it. So it is literally, I don't know common, but don't be surprised if you're at an education institution and you're like, wait a minute, doesn't that violate Title IX? Guess what? There's like a 99% chance that if you notice it, if it's that big, it probably does violate Title IX. And there are numerous court cases every single year of colleges and to some degree public schools continually violating, I hear more about the college ones, but doesn't mean it doesn't happen in public schools, violating and being taken to court because of violations of Title IX. Okay? So if you see something that seems unequal in sexes, it very well might be. You can look into that. And don't think you're the one that's automatically wrong. In sports, one thing I notice, and there's some details on this, but one thing I notice is K through 12, public education usually really tries to make all efforts for equal types of corresponding sports. If there's a baseball, then there's a softball. If there's a boys track, there's a girls track. If there's a boys lacrosse, there's a girls lacrosse. If there's girls gymnastics, they try to make a boys gymnastics. And I think it's federal, but it's definitely in a lot of states. If there's not a corresponding sport, then the other sex has a right to join the sport. So if there isn't male gymnastics, the male gymnast has a right to join onto the female gymnastics teams with slight state rules sometimes. I noticed in colleges, they usually go for proportional numbers of participants. They usually run on, well, if there's X number of female athletes, there should be X number of male athletes based on the enrollment percentages of the colleges. So they aren't looking for a one-to-one sport equality type of system. They're looking at a overall numbers proportional. Okay, so that's typically what they're looking for. But there's also ways to talk with the federal government and make sure you're in compliance. Now, there's a very second major implication of Title IX, and I'm not entirely sure if it came about right at the beginning of Title IX. I know the discrimination based on sex definitely did, and I don't know if this interpretation came about a little later or if it was right in from the beginning. Regardless, it is very important in Title IX right now. It is the school's requirement to respond to and to try to prevent and respond to sexual harassment and assault. Now, the reasoning that Title IX, which is basically against sex discrimination, but it's also no one shall be excluded from participation or denied benefits of an education based on sex. So the reasoning goes that schools are responsible for providing a service that does not deprive someone or opportunity based on sex. Sexual harassment or assault, the argument can be made that it makes it very difficult to participate in education if you are continually being sexually harassed or assaulted. Thus, the schools have a duty to educate, try to prevent, respond to sexual harassment, and respond to sexual assault at their institutions. See, there's no law from the federal government that says it is federally illegal to be denied education because of, let's say, fist fight violence. And so a school may say, of course, we don't allow fist fighting, and if someone does it, you'll get punished and the authorities will be noted, but the school doesn't have a whole system of education to educate people not to fist fight. The school doesn't have a whole system set up to adjudicate and find out what really went down with the fight, to investigate, okay? So because there's not a federal law that says you have basically a human right not to be denied education because of fistfights. But there is this human right to not be denied education based on sex. So the schools are held to the standard of addressing it. So basically what the federal government says to the schools is you have to address it. You have to have a sexual Title IX department. You have to have sexual harassment and assault education. You have to have a reporting process. And when the reporting process happens, you have to follow up and mitigate punishment and make sure it doesn't happen again. to those involved because it deals with a federal right. Now, under the Obama administration, the Obama administration said to colleges that in order to prove sexual harassment and sexual assault, it's basically the school had to respond and they had to create discipline or respond to the situation if there's 51% of evidence that said it happened. So it said to the colleges, you've got to investigate and you have to respond if it's, quote, more likely than not harassment or assault happened. And the investigation could not look like a trial. It had to be much less trial-like. And if the schools did not respond, did not create investigations, and if they did not judge based upon like 51% of the evidence, the federal government could come in and hold them basically in contempt of the law and take them to court and set fines. Now, this is changeable by administrations. The Trump administration came in, and it was the education department. So we do call it not the Congress, not the Senate, not the Supreme Court. It is the Obama administration because they run the education department, and the Trump administration runs the federal education department. Well, they said, make it more like a trial. The reasoning was to balance, if you're going to accuse someone of something that is like sexual assault, then it should be more trial-like, and it can't be just 51%. You can't just sort of believe one person over the other. There has to be clear and convincing evidence. So we see the big switchover in sexual harassment and assault cases in colleges, and I assume it is also for K through 12s, is that the process becomes much more trial-like and less like businesses investigating something. Okay, and there was also a change, one that the assault has to happen on campus now for the campus to do it, and also that the assault is still, if someone has been assaulted, it is assumed that they are being deprived of education, so the school has to respond. But for the harassment side, if someone's offended because they're being sexually harassed, the federal government says it has to be so severe that it does follow the words of the title, which is denies them education. So this harassment has to be so severe that someone who's being harassed can't get the education. So those are the major, where it was a few years ago, where it is currently, and we'll see where it is going in the future. Now notice, the government sets the minimum that the colleges must do, otherwise they face penalties, okay? Schools can always kind of make their own rules. But considering the government sets what the government wants for Title IX, if the schools punish someone under Title IX, and they don't follow the government, then someone could get them in court cases. It's entirely possible. So in these cases, really what the government says is the guiding principle, and then the schools have a little bit of wiggle room, but they can't do less than what the government says. So by law, colleges have to investigate sexual assaults, judge whether a sexual assault happened, and if a sexual assault happened, have to dole out appropriate punishments to people who did sexual assaults. Well, what that necessitates, and by federal law, they have to do that. Now, what that necessitates is that colleges define what sexual assault is. Now, some of this comes from state law, and some of it comes from the actual college's laws of what's going on campus. What they determine is sexual assault. They have rules. They're all generally the same, but there are a couple differences, and those differences could be the difference between a sexual encounter and a sexual assault. If somebody doesn't know the rules that they're supposed to be following for a sexual encounter at their college, their specific college. For example, some possible rules that colleges might have. Alcohol and drugs could remove consent. This is a fairly common one, in the sense that if alcohol and drugs are involved and someone thinks they are sexually assaulted, the alcohol and drugs removes the person's consent and they can't give consent to an encounter. Repeated asking for a sexual encounter could be considered a coercion, and that would remove consent, making the encounter judged possibly as a sexual assault. I should say that the definition of consent means both parties agree. Okay, consent is both parties agree to what's happening. Body language could remove consent, and all of these I have either seen in court cases or they are from the stated rules. Every college has a stated sexual assault consent guidelines on their website or for the students. Body language during an encounter could remove consent. And if it's continued, it could be sexual assault. Consent can be removed at any time. This is basically a legal thing that that's a legal right in every state. Consent can be removed at any time, and the encounter has to stop. Some have affirmative consent must be given. It's not that someone says, I don't want to do this. It is that they have to affirm and say, yes, I want to do it. So silence wouldn't be consent. It has to be in the affirmative. Sometimes it's at every stage of the encounter. So if the encounter changes from one thing to the other, affirmative consent must be given again. Some places, the consent must be verbal. And so all of these, they all have basically the same idea. People must consent and agree to an encounter. That's the basic idea. But the slight differences of what creates consent or when consent can be given and not is different state by state, college by college. And so if you don't know, all of a sudden it becomes a sexual assault that the college has to fix and punish if it's proven. Otherwise, they're in violation of federal law. And that is a quick overview of possibly the most powerful anti-sex discrimination law in this country's history. At least when it's concerning education, it is the top number one. All right, thanks for watching.